Welcome to the No Say Project. I'm your host, Marc Stevens, author of Government Indicted. Website is markstevens.net. Glad to be with you here live from the fortified compound in Mesa, Arizona for what is today? Today is the 15th. Yes, February 15th, 2007. And just to let you know, we'll not be live this Saturday. Will not be live this Saturday. Should have all new material, though. And we can even play this for those who aren't able to catch the broadcast live. But I'm glad to be here. I'm glad, appreciate everyone's support. You can tell we don't have a lot of money into this program. But damn it, the material more than makes up for it. People aren't tuning in to watch me. But it's the material. We're not afraid to take on critics in real time. And that's why, for those who haven't heard yet, we had a real big surprise last Saturday. You can get that show at markstevens.net. Very aggressive YouTuber. Someone actually came out from behind their keyboard to make fun of me. Came on the show, and so check that out. I personally think it was quite embarrassing. I actually felt at one point, especially now, he still wants to go. He wants to do it again, so he may record something, and I guess we can have that for the broadcast on Saturday. I'm almost feeling bad for the guy. If he's not being paid to troll me, well, if he's being paid to troll me, he's doing a really, really bad job of it. And if he's not being paid to do this, then I really feel bad for the guy. I mean, he doesn't have a coherent argument, period. You don't have to take my word for it. You should never have to take my word for anything. You just go look at markstevens.net, check out the last show. It's, it might actually do more harm than good as far as getting critics to call the show, because if people who are very critical of me listen to that and listen, no one can really do much better than that. I mean, the position we have here on the No State Project is based on evidence. It's based on logic. No one's been able to show a flaw in the logic other than to say it doesn't apply or Mark, you're an idiot. So ad hominems and double standards and logical fallacies aside, nobody can show where the facts are wrong. Or, well, look, because the facts are not wrong. The facts are very clear. There is no government. Demonstrably so, which is why none of the people who are critical of me, who insist, well, Mark, their state exists, just because you don't believe in it doesn't mean that it does. Yeah, so, well, the other side of that is just because you believe in something doesn't mean it's true. Just because you believe that there's a state doesn't mean that there is one, which is why ICBM Catcher and all the other critics who have insisted on that, when you ask them to prove that that's true, they run away. They will do anything but actually try to show proof. So what ICBM Catcher did was, when confronted with the fact that you don't have any evidence to support your conclusions, you just go to the double standard. Well, you're an idiot, Mark, because you're asking for something where no evidence is required. Oh, what? By the same people who are putting forth the argument. Yeah, just say no evidence is required. Then why is evidence required to counter it? Ridiculous. I do have a new video, too, so I'm going to do my best to get that up there today. I guess I could talk about it. And although you want to join the show, it's 218-632-9399. 218-632-9399. And then Skype is Frank Rizzo 3. I do have to say that the chat is a damn mess. And I just want to publicly express my disdain for what has happened to something that has been very valuable in helping people, but there are a handful of people that just can't help themselves. They just can't help themselves. I say, if you want to talk about damage control, fine. Don't flood the chat with that. Put something about damage control like I already have in a video from a radio show that I did. Put it on the forum and post a link. Newbies, damage control. Here's the link. Go to the forum. Go to Mark's Wiki. Do not, I said, don't copy and paste wall after wall after wall after wall of text, and it doesn't stop. So no good deed goes unpunished. So there's a few, and I'm not singling, one or two out. There's more than a few that just can't. So get with me first. If you go to the chat, get with Gary. You're not going to have a problem there. There may be some other people that are going to give you a rash and a crap, and I apologize for that. But I can't moderate the chat because I'm actually helping people. Good people like our friend Bill up in New Hampshire. So you have to excuse if I don't do it. So please, if there's people in the chat that I can't moderate really close, don't take it as a personal attack. And please don't take that. That is because I agree with that and I want that. I don't. I'm getting real close to starting a whole new chat, and I'm just going to pick a few people to go in there, and this way the new people can be completely shielded. I'm going to have to take the link off the front of the website, Galvin. I'm going to have to do it. I can't just have anyone going in there. Should be people that have contacted me first. Oy vey. But we do have a new video, and I'm very happy about it. What you want to look, it's bad enough when you're being attacked, and then you get into the chat, and you got people just spamming and whatnot. It's stressful. And it doesn't help matters much when you're going against professional litigators, okay? This is something that needs to be taken into account if you're going to defend yourself, making a principled stand. I'm with you. I think it's great. Is there a risk that things could get worse? That they are, because you're dealing with criminals? Yeah, they could triple the fine like they do in some places. I think that's what happens in Israel. But you're taking a principled stand. We know that there's a risk. We call it damage control. Damage control doesn't mean that you're just laying down and making a deal. No, you're fighting them tooth and nail to limit the damage they're going to do to you. And we're doing it with the full knowledge. We know that they're crooks. Well, Mark, where's your evidence they're crooks? Because they're men and women forcing us to pay them. So, and you can say, yeah, but there's more to it than that. Are there any facts that negate that? Any facts at all that negate that they're men and women forcing us to pay them? Oh, and here's a clue. When you say, I would like to pay less, you are being forced. And that's something I'll address with ICBM Catcher. He says he's not forcing him, but he would like to pay less if he could. See the crap you got to deal with? So I have to deal with status BS, and then I got to deal with people, babies, and people bitching incessantly on the chat. But I don't want. All right. So again, getting back to this, prosecutors usually just sit there and not say a word in their own defense, in defense of their own complaint. And that's because they have no defense to the motion to dismiss, because there's no evidence to put up. So if you watch, you can accuse them, like I've done, of prosecutorial misconduct. You are accusing them of being criminals, and they don't open up their mouth because they're usually very confident that the one that is in the conspiracy with them to take your money away from you, yes, the judge is working with the prosecution. Well, where's your evidence for that? Gee, who's forcing you to participate in the proceedings? Is it the prosecutor? No. Now, the judge is the one who's going to issue a warrant. The judge is the one that's forcing you to participate. So the facts tell me if the judge is forcing me to participate for an answer to the prosecutor's complaint, then these two people are working together. They are conspiring to take my money. And if you have any evidence to the contrary, 602 218 632 9399 is the number. Skype me at FrankRizzo3. I am me first. Just send me a comment, and then I can bring you up on the show. Don't just ring up the show. So I don't want. I have this video where I do have an opposition. It is Gene Barrett, who's a prosecutor in Jefferson, Ohio, or Ohio if you are native. And he is responding to the motion to dismiss for prosecutorial misconduct and Brady violations. And this is his second attempt. I don't go through all of it because I have to do a separate video for that to show all he did was restate. He came out and presumed his argument was true. We pointed out that's arguing without evidence. It's all circular. Well, where's your evidence that the code applies? Well, the code says it applies. Okay. Or a judge said so. You're not correcting the fatal error. You're not correcting the problem. So we show that all he did was restate his argument, which is not overcoming the motion to dismiss for prosecutorial misconduct, because you're still doing it. It's just like when I was accused of by a so-called anarchist that I was, when he falsely accused me of certain things, and then he apologizes but continues falsely accusing me. You're still doing it. You haven't corrected the dishonest thing that you've done. You're still doing it. You got to stop. So I'll go through that maybe in another video. What I wanted to show here, what I do in this new video, is to show how easy it is to discredit and defeat these people. Now, that doesn't mean for a second that the judge is just going to fall off his bench thinking, my gosh, what wonderful logic. Oh, my gosh, you just you destroyed the prosecution. No, but we know it does happen. What he does is, instead of addressing the actual argument, they straw man. And then they give you page after page of citations which are completely irrelevant. For those who aren't familiar, straw man is where you misrepresent or completely fabricate a new position that your opposition has not raised so that you can then easily defeat it. So what Gene Barrett does is say, now remember, filing a false claim in court is not only prosecutorial misconduct, it's grounds for disbarment because he's violating Rule 3.1 of the Ethical Code, the rules of professional conduct. Defendant contends that this honorable court cannot obtain jurisdiction over him without his consent. At no time was that argument ever made. So then he then goes and says, they quote, court cases, opinions. We address this jurisdictional argument with respect to personal jurisdiction. Many courts have addressed and rejected arguments similar to the one raised, i.e. that a citizen must consent to the jurisdiction of the court. This court and others have found that consent is unnecessary and irrelevant to a court's jurisdiction. Of course not. You're a bunch of crooks. And then he goes on and on and on and on and on with legal citations to supposedly prove that he has defeated the defendant's argument, which, of course, nothing of the sort ever happened because he didn't ever raise that argument about consent. Straw man. Yeah, that's exactly what you call it. It is a straw man. So I don't want anyone to ever feel really intimidated because the prosecution does respond. They typically don't respond because there is no valid argument. There are no magical facts that are going to defeat the underlying premise that I present here, that they're just men and women forcing us to pay them. And because of that, they keep their mouths shut and they let that scumbag with the robe on just say denied, denied, denied. If you don't like it, appeal it. And then they threaten you with a psychological evaluation because you had the audacity to apply basic principles of reason and logic. Yeah. Very easy to defeat the crap that these people are putting out. And you can hear an hour and a half of it or so of a very aggressive critic from last weekend's show. You're going to hear him fail absolutely miserably to make one lucid point. I honestly feel bad for the guy, but and just to point out, all the videos we'll have from now on will have the YouTube comments disabled. But unlike what ICBM catchers accused me of, you can still get your comments on the forum. Yes, you have to sign up. I know. But you don't have to sign up to have comments on the article that comes with each video. So I don't log in every day, so there may be a day or so if you're a new poster, especially if you have a link in there that has to be approved. But if you go in, you can see I went in today because I did a new video, and I approved all the comments. So there. I got to address an issue here, and I do address this briefly in the video. But looks like we're having a slow day as far as calls. The number is 218-632-9399, 218-632-9399, if you want to join the big show here today. It's this idea that's come out. It's a recent criticism, and it shows you just how desperate people are to try to discredit the work. I guess because maybe they feel it's a small show now, but you can see he is the website, the YouTube channel, which is No State Project, is growing steadily. Not by leaps and bounds. I've yet to have that viral video, but it is growing. So they come out, and criticism is, I'm trying to take the principles of logic that apply in a high school debate and apply them in court. And in court, that doesn't wash. Only legal logic applies there. And the stupidity of such a statement that non sequiturs, that you can actually argue non sequiturs, that just because you think look, it has no foundation at all. It is just a stupid criticism of the work, because bottom line, we got another person who just can't overcome the evidence and show a flaw in the logic. And that's why even so-called anarchists and voluntarists, especially people who call themselves ANCAPs, are so adamant about trying to discredit and piss all over the work that I do here. I can't even, and I know I've got to, one of these days I have to give a call into Free Talk Live, and maybe I'll do it tomorrow night and publicly correct the record, because even Daryl Perry on my network on the weekend show, LRN.FM, even he, someone who's a libertarian, an anarchist, a voluntarist, even he gets my position wrong. But I don't think there's any, I don't think there's any ill will there. He's not malevolent about it. He's just misunderstood about my position. But man, talk about really scraping the bottom of the barrel. You can't take the principles of a high school debate and try to put that into law. Hey, what a stupid thing. Wait, so you could just, oh, see, that's the thing, though. What they don't understand is the simple fact that most of the objections are based on logical fallacies. What do you think objection relevance is about? It's because you're bringing up a non sequitur. The two aren't related. They're not relevant. When you say assumes facts, not in evidence, you don't think that's based on basic principles of logic? Just such disgrace, just such desperation. I just would hate to see that anybody would be intimidated or would accept such stupid excuses to shy away from the work here at the No State Project and not challenge these people. And I think what's even worse is people being scared off by Daryl Perry. Well, I heard on Free Talk Live, and Marc is on that network, and he said, Daryl Perry said this. No, Daryl Perry is wrong. He's wrong. So don't be afraid. I've never given a guarantee. We have quite a track record, though, on the show. You can go to markstevens.net. You can see all the wins, all the successes. 3 continents, by the way. Many other people have replicated the success, and that doesn't mean that, and I don't post all that. So let me get to the phones here. We got Richard in Austin. Richard, welcome back to the show. What do you got for us today?
Hey, Marc. It's been a while.
It has. What's up?
Well, I had a few things, or 2 things that I've been pondering with regard to the work that you're doing, and I'll just get to it. One is, what would be, because basically, if in a jury, trial by jury situation, that jury is there because the state or the judge is saying, show up or we're going to punish you. So that jury who shows up, the people that show up, are under the influence that the laws, statutes apply to them. So is there a way that you know of or that you've used to show during the voir dire that this jury is biased because they're here? I mean, like, they are here because they think that the laws apply, and they're probably going to assume that the laws apply to me too, because they're assuming the laws apply to them.
Yeah, well, in Government Indicted, I go through that, and it's in the script for the voir dire of the jury. The problem is the judges won't let us ask the question, and they won't ask it. So if we have to appeal it, then it's an issue for appeal that we have a denial of a voir dire. We have to show that the questions are relevant to bring out whether they have any bias and prejudice. The question has to go and be relevant to whether the juror can make an unbiased decision based on the evidence. And if they already came into the court with their mind already closed to that if you're physically in Texas, the laws apply. End of discussion. That is not just jurisdiction. I know it's a big part of it. It's an absolutely essential element of the crime. And my basis for that is they're citing you for a code violation. And this violation there's only a violation because of the code. If there was no code, there wouldn't be a violation. We're talking about malo prohibita, where it's only wrong because some politician said so. So it's an essential element of the crime. And so even if we excuse jurisdiction, just for sake of argument, it's an essential element of the crime. There is no violation without that. And if the jury is coming in already with an irrefutable presumption in their heads that it's absolutely ironclad, then that relieves the prosecution of proving every element beyond a reasonable doubt, and that is a denial of a fair trial by definition.
Right. I mean, I'm pretty sure that most of those jurors would not be there if they thought it was optional.
And you can ask them, are you here today of your own free will, or were you, and you ask them a leading question, were you here in your own free will, or were you forced to be here? You should see the reaction. You would think that when juries
I've done a voir dire. I had a jury trial. Actually, they scheduled me for 2 jury trials in one day. I think that's unprecedented. I'm not sure. But they dropped the first one. In the pretrial hearing. It was kind of ridiculous. I mean, I'd love to talk with you about it at some point. But no, during the voir dire with the trial that they actually went through, I asked a very similar question. And one woman raised her hand and said, I don't feel like I'm forced to be here today. I said, it kind of like put me on pause. I thought, oh. So I asked her, I said, so you want to be here today? And she said, no. And then I got even more confused. I said, so why are you here? She said, because I don't want to face the consequences. And then I repeated it. I said, so you don't feel like you're forced to be here? And she said, no. And so it was just, I didn't really know what to say at that point.
I think you need better leading questions. I think you need some better leading questions.
Yeah. And so can I get to my second point? I mean,
yeah, of course.
So the other point was that my feeling on this is it relates to veganism, because you've talked about it late. I've been listening to your show. I mean, I know I haven't called in a while, but I really appreciate this, taking the next step to following the principles in a manner that is consistent, or following living your life in a manner consistent with your principles. And so there's this one argument that comes up, whether or not like eating the meat is a life-saving necessity. And part of that would be like, if all you had, if you were in the desert and you needed to like kill a creature in order to survive, or whatever the situation might be, like you needed that meat in order to survive. I just have this feeling that maybe the judges and the prosecutors and the lawyers are looking at this in a very similar way. And that is because their survival is based on this, the fallacy. It's based, they think that their survival, because it's their job, is based on forcing people into this circumstance. And so I don't know where to go with this idea that I've come up with, but it just seems like they think this is their only means of survival. And that's why they're doing it, and that's why they think they need to do it.
I think that a lot of them believe they're the good guys. Most people are probably not going to do something that they believe is immoral, that goes against the social norm. It's to relate to veganism. Most people will continue eating meat because so many other people do. It's considered normal. So as long as you don't focus on the suffering and the slaughter, then you're okay. And so here they think they're the good guys. They think it's the only way, that without I've spoken to enough of them to be able to say that, at least in my scope of influence, they actually believe that without government, it would be like Escape from New York. It would be absolute chaos, and people would be murdering and raping and pillaging nonstop. The world would be over. There's no evidence to suggest that at all, but that's what they actually believe. So if they have to bend a few rules, if they have to act in a way that's morally reprehensible, they look at it as necessary. I think that's something that you mentioned at the beginning. I don't think that they necessarily see it as the only way that they can make money. Certainly there's other ways, but I think they see it as they are God's messengers, that without them, all hell will break loose, that they are the only thing keeping society at any kind of reasonable state of peace.
Yeah. Okay. Well, very interesting. Marc, I appreciate your time. I'd sent you a long email a few months ago, just kind of explaining like what I think you're actually doing, and it relates to health, and it relates to the immune system. And I'd read this book a while back called The Medical Mafia. I'd highly recommend it to anybody who's interested in what the Western medicine system is doing to people. I call it the Western medical system, and call it conventional medicine or whatever. But basically, it's disempowering. And the author of this book had described that once one submits, like in a very general term, like submitting to an alpha or submitting to a system, then it has a dramatic effect on the immune system. Because then one is basically opening themselves up. And I really feel like what you're doing is like, it's like a healing. Like you're some kind of shaman, for a lack of better terms. And I don't need, no one needs your head to grow any bigger, Marc, but I think what you're doing is really powerful. So thank you. I love listening to your show, and thank you for what you do.
Oh, thanks. I
Really
appreciate
it.
that. I think as far as before you go, just to bring it back to the jury, I think it's very important to still try to do what we can to bring these issues up in a voir dire. Because, again, I'll keep repeating it. All you have to do is show that the question is relevant to determining whether the witness can be unbiased. So anything that goes to show that they're bringing presumptions in, especially if they're considered irrefutable by the judge, if they're bringing in irrefutable presumptions about an element of the charge, as long as you can show the relevance, the judge has absolutely no discretion, zero discretion to limit that. He only has discretion to limit irrelevant questions, and that goes right to the heart of the matter. And I still would make it a point, and some of the better leading questions you could ask them on voir dire is to really box them in and ask them if there were no consequences to you not showing up today, would you have shown up or not? Or you could, better question. So if there were no consequences to you not appearing today, you would have just gone about your life, wouldn't you? So isn't it
Hmm.
fair to say you were forced to be here? Because otherwise you wouldn't be here.
Right.
I think everyone should ask those
So at that
questions if they're going to get a jury.
is at that point, would it be the judge's like duty, you know, lawfully or in due process to dismiss the whole jury? Is that what you're saying? Like that's what they should be doing if you're able to show every juror has this prejudice that they're going to presume an element of the charge
Yeah, he should. But what
automatically.
they could do is they could do like with judges. They could pull the rule of necessity and say that, and ignore the fact that you're entitled to a fair trial, not a trial, a fair trial. And that so they'll say, well, if we disqualify all, we disqualify none. And that's the kind of stupid legal see, that's
Hmm.
exactly why they say these stupid things. Well, you have to use legal reasoning. Legal reasoning is crap. If we disqualify all of them, we disqualify none of them. So if everyone is biased against you, none of them are? Oh, come on. And they expect, see, this is why people like that need a prison system to try to get people to buy this crap. They learn that stuff in law school. If all are biased, none are biased. Oh my gosh! So if we're all tax evaders, none of us are tax evaders. Give me come on. If you're all criminals, no one's a criminal. You see? Stupid.
Hmm.
So
Yeah.
yeah, it's crazy. Well, I'm actually starting to get lined up with calls, and
Oh, great.
but I appreciate the call, and hey, and don't have so much time between calls.
Sure thing, Mark. Thanks a lot.
Appreciate it.
Love your
Richard
show.
in
Yep.
Austin. Thanks again. We're gonna go to a Skype call here. I'm gonna get. Hopefully he's ready. I'm gonna. We'll mute up for just a second there and see. Hey, do we got Moses? Moses, you're live on the big show today.
Hello?
Yes, you're live on the show, Moses. Where are you calling from?
Colorado.
What can we do for you today? What's going on?
Well, first, I wanted to thank you and give a shout out to my homie Joe from Copwatch, Hawaii. Without you guys, I'd still be stuck in some other stuff.
Oh, that's good to hear.
Let me turn this speaker down because you're lagging in my live feed.
This is the tech issue that's not on my side, guys. So
Okay,
far
sorry,
on my
I'm
side,
ready. I'm
there
ready.
aren't any. Okay, so
All right, so I was in a traffic case, September 7th last year. I was clocked. I actually was not clocked. I was cited going 10 miles per hour over the speed limit.
oh no.
Right. So, I didn't argue with the officer at the side of the road because that's stupid because they're crazy. Anyways, long story short, I submitted your motion to dismiss, and like 1 week before the arraignment, and the magistrate dismissed it without any reason whatsoever at all.
How do you know it was dismissed?
They actually sent me it back. Well, they didn't send it back. They filed it with the clerk and all that, and then he sent the response back to me through the mail, and it literally said, no recognizable grounds for relief. That's what the magistrate wrote.
That's not dismissing the charge. That's denying the motion.
Right. Okay, maybe I misspoke. What I'm saying is they denied the motion.
Okay.
Right, because in your motion that I purchased from you, it says, I request an explanation if you're going to deny this, and he didn't give any explanation at all.
Because there is no legitimate grounds to deny the motion because it's based on lack of evidence, and because there's no evidence, he can't give you anything without looking stupid like these prosecutors do. Yeah, he can say you're asking for evidence where none is required, but that's ridiculous. The prosecutor does have a burden of proof.
My thing is that so far, nobody has given me any response whatsoever. The magistrate at the arraignment did not give me any response. The district attorney that I talked to did not give me any response.
Right. Typical.
He spoke with me on the sidelines, but that's not on the record. That's not official. And unofficially, he claimed that the laws applied to me because I asked him, I said, why does, what evidence or facts do you rely on to claim that these laws apply to me? And he said, he said something like, because you got pulled over, because you're here today, and because it's quote unquote accepted. He said it's accepted.
It's accepted.
Yeah, it's accepted that the laws apply to you. So yeah, the laws apply to me. Apparently.
Oh, did you say? Well, I know you think that they do. Can you actually prove that they do? Where's your proof that a written instrument applies to me? I forget where what year it was for Colorado, but what evidence do you have that a 100-year plus written instrument applies to me just because I'm physically in Colorado? You got pulled over. Doesn't that presume? Didn't the officer already presume before I was pulled over that the laws applied? Yeah. Okay. So again, this is why we keep them on point. Again, just please answer the question. Where's your proof that a 100-plus-year-old written instrument applies to me just because I was physically in Colorado? Well, you're here. Yeah, I got it. I'm asking. We know I'm physically here. I'm not disputing it. And then the part about accepted, this is what they would say in Canada and other places as trite law. Everybody knows that. And like, object, excuse me, are you actually trying to use an appeal to popularity as evidence evidence to prove an element of the charge? At that point, he'd probably just laugh and smirk and just say, well, we'll see what the judge has to say about it. Let's see what my partner in crime, let's see what Paulie has to say. Oh, that's right. F you, pay me.
Exactly. That's exactly what happened. He got saved by the bell. The judge recalled the case because at my arraignment, he kept sending me off to the sidelines to talk to the district attorney and negotiate a deal. When I kept telling him, no, I want to plead guilty right now. I just, have some questions that I want to ask the courtroom to, gain clarification on what's going on here. And the judge just kept shutting me down, didn't want to hear my questions. You could actually listen to the court case on Cop Watch Hawaii's website. Right now, it's like a 30-minute arraignment where the judge he refused to let me ask any questions. I couldn't get past the first one of, do I have the right to a fair and meaningful hearing?
That's why what we want to do is we want to get straight into that's why we filed a motion to dismiss first. So when we're there, okay, in person like that, then you can, when they say you're ready to proceed, objection, no, none of us are ready to proceed. We have a motion to dismiss pending. And so does the prosecution have sufficient evidence to overcome the motion? And then you should know if they say yes, or do you have the complaint? Objection, are you saying the evidence is on the complaint that proves that some written instrument from 120 years ago applies to me? Because if you do, great, I'll plead guilty right now.
Right. Well, check this. He said the magistrate ended up setting it up for a disposition hearing, right? So
Okay.
He set it up for 3 months later. I went back to see an actual judge this time. And that's what I was going to do. My new game plan was I'm going to go straight for the jugular on this one, right? I'm going to go straight for, where's the evidence that the statutes and codes apply, but this judge, before he even called the case to the room, he called 2 sheriffs to the courtroom. The sheriffs weren't there all morning long, and he called 2 sheriffs to the courtroom. And as soon as I got up there, he motioned them and they surrounded me. Like immediately I was already being surrounded.
Jeez.
I opened my mouth one time and he this is what I asked him, Mark. This is what I asked him. I said, objection, judge, do I have the right to ask questions right now? And he said, no, you don't have the right to ask questions. Your questions have been answered at your last hearing. And then he threatened me with a contempt charge right then and there. So, there's nothing I could do really because I didn't want to go to jail.
Well, understood.
So right now I'm actually in the process of filing a judicial misconduct through the state against him. But my question for you is what do you recommend doing next? Because I filed basically the motion to dismiss at the arraignment. That was denied.
Okay.
I refiled a motion for prosecutorial misconduct the second time. I haven't heard a response from that, but it sounds like it was denied. In the courtroom on the transcript, the judge literally said, "The fact that you're standing here in front of me confers jurisdiction," end quote. And when I opened my mouth to say point of clarification, he immediately cut me off and said, "You're in contempt. Like if you don't,
Yeah, yeah, and so because the question would be, so if I never showed up, you would have no jurisdiction to issue a warrant for my arrest if I didn't, for not showing up. Oh, I
didn't have
still
a
would.
chance
Then my being here is completely irrelevant to whether you have jurisdiction or not, isn't it, you jackass? But of course, he had to pull the intimidation card on you to keep you from asking a follow-up question to call him out on this obvious verbal diarrhea. Again, I'm not one of these types that just because some lawyer with a robe on said something that makes it true. Look, something is not right or wrong because of what is dictated by a man in a robe sitting 4 feet off the floor. My gosh, how do you? I'm getting a little ticked here, but how the hell do you possibly get an advanced university degree and actually believe in such crap? Whatever a judge says is true. Fungal. Why don't you be able to provide your services to the market on a voluntary basis and see if people are willing to pay you without being forced? That'll do more to determine whether what you do has any merit or not. Okay. So I would, as long as he hasn't formally ruled on the motion to dismiss for prosecutorial misconduct, I would ask the clerk to get me a hearing on that motion prior to any kind of trial date. And I would probably put in to recuse this guy. And again, you can use that as grounds for an interlocutory appeal or a petition for a writ to stop the trial if you feel you need to do that because this guy is so crazed. The fact that he is restating the prosecutor's argument without any evidence whatsoever and intimidated. You have to put in it, he bullied you. He bullied you the whole time. He said, and I would write out, he said something really stupid that my physical presence in the courtroom gave him jurisdiction. Point out that if you never showed up, he'd issue a warrant, which would mean, according to his own reasoning, he'd have no jurisdiction to issue a warrant. And then when you went to get him to clarify that because it was so stupid, he intimidated you into backing down and not calling him out on that crap. So
Exactly.
So motion to recuse, motion to dismiss for prosecutorial misconduct, and I would get the motion for in limine filed also, pointing out that the prosecution should not even be able to argue this written instrument applies to you because he's got no evidence that it does.
Okay. Should I be filing that motion in limine around this time or?
Yeah.
Okay.
Yeah, you already said that you had nothing back on the discovery request in Brady, right?
They did provide the discovery, but they completely ignored the Brady altogether.
There you go.
And that was part of my prosecutorial misconduct, as I said, you didn't even. That's a Brady violation, right?
Yeah, there you
you
go.
didn't even do any Brady.
So they're both appropriate, and I would move to get move to have them both put on the docket for a hearing, both of them.
Okay, well, I just wanted to call. That's Judge Cox of Adams County Court. He's a Nazi in Colorado. Stay away from Adams County.
Adams County. What's his first name?
I think it's Michael Andrew Cox. That's Cox.
Okay. Got it. I'll put it in the show notes.
I just I wanted to ask you a question on, something that's been running around in my mind real quick. Because, I was talking to one of the district attorneys, right, on the sidelines, and I asked her, what evidence do you have of personal jurisdiction? And she said, personal jurisdiction is for a civil charge. This is a criminal charge. We don't need to do that. And then, I was thinking about it later, and I was like, oh, yeah, criminal charge, there needs to be harm or injury, right? So I was like, I could have said, where's the harm or injury?
Oh, well, they both need to have it. So you know what? When you get someone like that, just use territorial jurisdiction instead. Bypass any of the stupid crap that they may say. That's civil. Where's your
right.
evidence for territorial jurisdiction? They're going to play their games. It's just like, when they talk about harm or injury or corpus delicti. There's a loss, harm, or injury is only for civil. No, it's not. That's what the corpus delicti, the act and the result. That's
Right,
why
but
I had to put in the motion. I had to put in there that that's an adversarial proceeding, and that cuts through for civil and criminal. So whatever whatever stupid phrase you want to put on it, lady, I don't care. Is this an adversarial proceeding? Yes or no? It is. Well, adversarial proceeding, whether it's civil or criminal, doesn't it require a legal injury? These people.
But I was studying the criminal law a little bit, and I looked up what the difference is, and my point is, it seems like under criminal law, what they're calling criminal law, is only the government is allowed to charge people with quote unquote crimes, right? And I was thinking, I think if the individual person had the right, to charge other people with crimes, there'd be a lot more justice in the world.
Well, they got control of the grand jury system, that's for sure. But the only difference between a crime and a tort is who brings it and the jail time. Those are the only those are the two differences. Well, and then you have the crime. It's beyond a reasonable doubt. The burden of proof is not a preponderance of evidence beyond a reasonable doubt. But the main difference is who brings it. It's brought on behalf of the.
And
Sorry?
Going back to what that first caller said is, when the jury's talking about, like what you said, they have to prove it beyond a reasonable doubt. Like the jury, what they don't instruct the jury is that not only is the jury going to, what's the word? They have to judge the facts and the law. Like they get to do both things.
Yeah. But even if they weren't judging the law, the fact is there has to be evidence that this written instrument applies. To just say it does because it's accepted, no, that's not beyond a reasonable doubt.
Right, there's zero evidence, so how could you even consider it?
Yeah, that's why I would say I would put him in the form of a question. Did you just appeal to popularity for an element of the charge? You're seriously playing God with my life right now, and the best you have on the single most important element of your charge, you're going with it's accepted.
I just think it's funny because all this over a 10 mile an hour over the speeding limit, and they're threatening me with jail, and he basically made me feel like a serial killer up there. I felt like I was a hardcore criminal.
Well, sure. I was getting ready to when you said you had it dismissed, I was getting ready to
Victory screech!
do this. So I think what's offensive is that the real crime here is you almost got a victory screech that was unwarranted.
Yes, I'm sorry I misspoke. My first time on your show, Mark.
Well, hey, you still have time to prep and get ready so that you can call in and get a victory screech.
Yes, sir. That's what I want. That's what we want. I think that's what we all want here.
All right. Well, I have to get to one last caller before we're out of time, but I appreciate the call. I'll put Michael Cox and whatever contact information we can get up there. If you can get it for me and send me the link, that would be great. We'll get it in the show notes, and we'll have him. Hey, when people do a search for his name, they'll find my website. So, and they'll find some information about him. So try to get that to me. I appreciate it. And keep doing the role playing. That's the best way to prep.
Right on, Mark. You have a good day. Thank you, sir.
Appreciate it. That was Moses in Colorado calling on Skype. Appreciate the call. All right, let's see. Where are we here? We got Trevor calling again from Oregon. Oh, nuts. You see, now I mentioned that there were no tech issues on the big show today, and I just did one. How the hell am I supposed to disconnect that without... Oh, I'm so sorry. I have to try to connect back to the caller line while having it muted.
Please enter your host.
Okay, here we go. Hey, I'm connected. I have to now get rid of the. Oh yeah, I already have the entrance. And okay, so I don't think I was able. Okay, do we
Hello.
have Trevor on the line?
Yeah, Mark, how you doing, sir?
I'm doing well. Hey, I'm really sorry about that. For some reason, when I got because Moses called on Skype, and when I deleted, ended the call with him, it took everything with it. So not a big tech issue for today, but all right, no biggie.
Yeah, by comparison, right?
Yep. Yeah, we've had some bad ones. I didn't even hit the microphone today and get that awful static. So we are doing pretty good. So what do you have for us today? What's going on in Oregon?
Just a couple quick things to share with you real fast. I've been tuning in some new listeners to you who kind of find themselves in situations that are in need of your assistance, and got a couple new free thinkers. And this last week, my goal for this year was to deal with the state of Oregon and the garnishment that they have on me. And over the course of the last week or so, I spoke with an attorney over the phone to kind of help guide me with some of the paperwork. And in the conversation of the call, I started kind of going through the questions as you put them, and wanted him to provide the answers. And so when I asked him, what facts or evidence can he supply or have that would prove that the code applies to me, Constitution code applied to me, he waited for about 10 seconds or so and just said, well, can you come in and talk to me? Can we sit down? And I thought that was pretty good. So I sat down and talked with him for about an hour. We did some role playing in there. And by the end of the hour, he just couldn't believe where I was coming from. And prior to me going into him, I had asked him to take a look at three things. Number one was your website, to listen to some of your call of shame so that he could understand my reference, my point of view. Second one was the Joe Bannister story, and the third one was Aaron Russo's Freedom to Fascism. So I asked him just to take a look at those three things before we sat down so I didn't sound like such an idiot, and he could understand kind of my point of view. So I really appreciate you being able to do what you do and kind of preface what it is that I'm trying to get accomplished on this end, and explaining it in terms that they understand.
So you had a few people that you brought over to the dark side, the rational side.
Right, some free thinkers who.
So we can have the victory screech, right?
Victory
Absolutely.
screech!
So today was a triumph.
Very nice. So I think I even got an attorney to get hooked on you, at least for nothing else. In his words, he found that conversation absolutely fascinating.
Was he able to produce any evidence that the states and citizens are real and that their rules apply to us just because we're physically in Oregon?
Absolutely not. And in fact, we did some role playing through our conversation, and every time that we would kind of get down to where we're looking at the actual facts and evidence, he'd always take a sidebar and say, well, this is where the courts are going to do this and do that. And each time that we did that in that conversation, it always boiled down to brute force. So basically what you're saying is when I ask this question and they can't answer it, it means that somebody's coming after me with a gun or a weapon. And they're going to take away my freedom. And he concurred 3, 4, 5 different times throughout that conversation that was going to be the end result. And I think I kind of got him to open up his mind a little bit as to what type of profession he's in and the type of psychopaths he's dealing with.
I'm sure if he's really being candid with you, he has experienced a few people that had psychopathic tendencies, that they were easily enraged, callous disregard for others, and very, very poor coping skills. I guess I covered that already.
Yeah, and he definitely brought up times where he's had judges freak out and yell and scream at him, and he doesn't like that as the attorney, so he bows down to that. And it's like, well, what, you got to have some pride and you got to have some backbone in what you do. If you're not willing to stand up for the principles that the person's paying you to deal with, then you're probably in the wrong profession.
Yeah,
And
yeah, of course. I've said to attorneys many times that when they said that that you're inviting contempt or they could destroy your career. I said I get that the judge can do that. I know they're crooks. They're vile, vile people. Um, I just want to know if you're honest when you take that $10,000 retainer. Are you telling your clients before you take the money, there are challenges that I could do that have been proven to get things tossed out. I'm not going to do them because I don't want to risk my career. I think that's part of
right.
full disclosure. I could respect that, you know, um, but they don't. They're not going to say that. Just like I'm sure Mark Victor is not telling his clients when he takes a huge retainer, oh, by the way, I never took the oath to the bar. I took the Donald Duck oath. I never swore the oath. He's not going to disclose that because it would destroy his career. I just think that when you're putting that's a straw in your hat. I just believe that there should be full disclosure to the client to know that they know who they're dealing with. But for at least saying I'm not going to challenge the very foundation of the prosecution's case because I don't want to risk my career, that should be disclosed. That should absolutely be disclosed.
Absolutely, and we should have the option to back out at that point. Which obviously, if they say it up front, you can. Two other quick things, Mark. I know we're short on time. I just wanted to cover this with you, and I don't mean to critique you, but I find that asking your questions kind of in a different way allow for the conversation to get started a little bit better, but also, I mean, at the end of the day, they still transfer you to the other department or say, I can't address that issue. But let me get your opinion on this. When speaking with representatives specifically for taxes, what I'm dealing with right now, and they always say, well, the code, you violated this code, and that's why we are punishing you with these fines. And my first question right after that statement is, does the department have to follow the code and the Constitution? And they always say yes to that. I follow up with can the filing of information be used against me? And they usually kind of hem-haw around a little bit with that one. Well, it can and it cannot. But definitely it can. Great. Well, then doesn't that conflict with the Fifth Amendment that says that I'm not required to provide any information that can be used against me? And I find that in asking it that way, that they conceptually they get it easier than conflating it with, well, I'm not here to talk about the constitutionality of the code. But I think that it drives a little bit quicker to the heart and easier for the frontline customer service representative to get their head around it, in that it's a conflict. I think it allows them to get a little bit more on your side and not so adversarial in conversation. But I wanted to get your opinion on that.
It's too easy in my experience for them to get away with that because the more savvy ones, because they're not all going to be dumbstruck by it, and I'm surprised that any were, because the pat answer is, at least the IRS is notorious for this. Well, we're not a criminal. We're not indicting you. We're not. No, this is just civil. We're not. This isn't a criminal investigation, and then they're off the hook. I think maybe a better way to go about it would be say, would due process be violated if you were to come after somebody without evidence to support your claims? And then, well, yes, of course that would violate due process. Okay, great. And then get into it. So first get an admission that that's a due process violation. And then when you say, well,
Okay.
you already admitted that it would be a due process violation. Now we've come to a point where you have no evidence. I can go to another department. That's fine, and I'll do that. But from where we're standing right now, shouldn't you put the brakes on and not proceed against me until you have evidence? Because I wouldn't think you want to violate due process. And I want to point out, when they do the State Department two-step and they start kicking the can, that doesn't mean we're not accomplishing anything. You have to keep track of the people you speak with and the date and time. And you need to keep a record, because you want to be able to show, I went to this agent, I went to this agent, I went to that one, I did exactly what they said. I went to the legislature. So I spoke with Marvin. He's the This is in Maine. He's the chairman of the tax commission. I went directly to him, and he said he had no evidence. So you can show no one in your organization has this evidence. So if you're not willing to throw it out now, can you direct me to exactly who would have this evidence? And if they don't have it, wouldn't it be a proper to abate this? So especially if we're going to go through with a claim against their insurance, when you can show. So this is what I did with Adam Kokesh in Arizona. I went to the agents, the supervisor, I went to the county attorney, and I went to every member of the board of supervisors so that I could then show no one in your organization. So I don't want anyone thinking, based on what you were saying before, that there's no merit if you're not able to get anywhere. You're making a record where you're asking for the evidence and they don't have it. Because at the very least, we should be getting a strong presumption in our favor that the fact not appearing is presumed not to exist. And when you have a record that every person I talked to, even though they were making these decisions against me, kept on kicking the can down to somebody else. No one at this organization has the evidence. That's a pretty good factual basis to be coming at this from. Because what is the reasonable opinion drawn from that? You go to every person in the all the main people in the organization, the top guys, you're asking for evidence their claim is based on, and no one can give it to you. Doesn't that, at the very least, raise a presumption that there's no evidence against you?
Yeah.
So there is merit to that. Because the only thing they could turn around and say is, we're not required to have such evidence. Why? Because you said so? Oh, some guy who died 150 years ago said so? So there is merit in making, and I recommend we all do this, make a record of the people you're talking to. And if you're in a situation with property tax or something like that, estate tax, just save yourself the time. Call the chairman of the Senate and House Tax Committee and ask them. So when they say, you need to go to the legislature, they're not the ones making the argument or the claim against me. But I'm way ahead of you. I already did. I spoke to Marvin on this day, and he has no proof. Now, can we get down to brass tacks here? Why would I go to the legislature if a police officer is claiming I broke the law?
Right. And at some point, maybe I can get a little more in depth with you on that one. The last thing I wanted to share with you before we run out of time today is when it comes to the letters that I'm sending, as they get progressively more and more aggressive with their demands, usually by the time when they're saying, this is your final notice, I include this, I include the Fair Consumer Reporting Act 616, Civil Liability for Willful Noncompliance, USC 1681N. And in that code, it says that, if you willfully and knowingly provide to credit reporting agencies false information, that you as an individual can be held responsible and fined between $100 and $1,000 in addition to attorney's fees. And when I include that in letters, I've only done it once. It was with the IRS, but that was the last letter I ever received from them regarding filings, and I addressed it to the person who was coming after me, and told her specifically that if she continued to send me letters absent of any facts or evidence, that I would pursue her personally. And that was in June of last year. I haven't heard back from them since. So hopefully, I don't know if that helped. I'm sure it did in some way, shape, or form, that it kind of got their attention that there's other codes out there that can be applied. If you're going to continue to apply yours to me, then it's a double-edged sword. And
yeah,
so
we're out of time. I think the better thing to do, and I think I've seen better success, well, at least similar success that you've had, is to put Title 18, Section 1001, which are false statements, which is a felony. So,
okay.
And that's
sorry, you said Title 18 what?
Title 18, United States Code, Section 1001. So when for example, when the IRS turns around and says that when I ask for evidence proving a 200-year-old written instrument applies to me, and that I don't see any evidence to prove that claim is true, they turn around and say it's a frivolous argument the courts have rejected, and they have this 80-page document. Well, when you ask them to prove that, they can't because they're lying to you. There's no such thing in it. They may eventually put it in there. I don't, but no court has ever come out and published an opinion that says asking for evidence is a frivolous argument. The day they do that, well, nothing's going to change. But if they do that, yes, things are going to be, that will be cited and things will be a lot more difficult. Yes, that certainly will. But they haven't done it because I doubt they're going to say that asking for evidence is a frivolous argument, because that really kind of guts everything that attorneys do, defense attorneys.
Mm-hmm.
That would mean that every cross-examination is a frivolous argument, a series of frivolous arguments. I don't think any court, because it's about making things look good, and I don't think you can make that look good. To say that a question of fact is a frivolous argument is so unbelievably stupid that it takes people from the IRS to say things like that. And anyone who says a question of fact is a frivolous argument, you're an idiot. I know I usually don't engage in insults, but that is so stupid. That is so condescendingly arrogant to people that what else do you say? You're a fungal, you're an idiot. That's all I got to say on that. Well, I'm sorry, we are out of time, so real quick, did you have anything else?
Oh, hey, just wanted to say thanks again, brother. I really do appreciate it. I listen to your show religiously 2 times a week, and I thank you so much. I really think you're doing a great service.
I appreciate that. I'm glad I'm able to help, and call again to keep in touch. My name is Marc Stevens. This is the No State Project live for February 15th, 2017 there. And we will not be live this Saturday, the 18th. Will be a pre-record, should be all new material, but it may include some of the material from this here show. May actually be, some more of ICBM catcher making a fool of himself. But hey, we'll see. There should be new material regardless. So if you missed this, it'll be available at markstevens.net on my YouTube channel. Also, check out, it should be up today, new article and video regarding not being intimidated by prosecutors just because they're experienced. If they had the evidence, they would be able to provide it. So no amount of education, no amount of experience is going to get them to be able to overcome the motion. Because if there was evidence that these written instruments from 150 years ago, if there was any evidence that they applied to us, they would just provide it. They wouldn't make excuses. They wouldn't have double standards. They just put the damn evidence on the table. And for those who think that states and citizens are real, we do 4 hours of broadcasts a week here on the No State Project. 4 hours where you have an opportunity to confront me with your evidence that there are citizens and that there are governments and that there are states. Because you have to prove that before you can prove that their rules apply. You're going to have to be able to provide evidence. I mean proof. Not opinion, not logical fallacies, not proof by assertion, not just because you said so, not because you believe that they are God's messengers on earth. You have to have actual evidence that reciprocal obligations of allegiance and protection were actually created. That's the only way you can prove that there were states and citizens. So, I'd love to hear your evidence, but we are completely out of time. We're a little bit over. This has been the No State Project for February 15th, 2017. Glad to be with you. We won't be live on the 18th, but we will be back live next week on Wednesday. So till then, salud.